Come on in. Go inside.
An invitation into Donald Trump's world. Footage from 1992 found in the NBC archives shows the future president welcoming Jeffrey Epstein to his Mar-a-Lago estate. The get-together more than a decade before Epstein pleaded guilty to prostitution charges in Florida. Both men are seen enjoying themselves, Trump pointing out women dancing in front of them. An apparently friendly encounter with a man the president is now looking to distance himself from.
Well, I knew him like everybody in Palm Beach knew him. I had a falling out with him a long time ago. I don't think I've spoken to him for 15 years. I wasn't a fan.
Epstein, who has pleaded not guilty to federal sex trafficking and conspiracy charges in New York, is fighting to be released from jail while he waits for his trial.
Hey all, it's Adam here. Here is the thing about courtrooms that television never quite gets right. It is not the dramatic outbursts or the surprise witnesses that actually decide cases. What decides cases, what makes jurors lean forward in their seats and prosecutors breathe a little easier, is when the defendant does the work for them.
A new chapter in former President Donald Trump's legal troubles set to unfold later today right here in South Florida. Donald Trump's Mar-a-Lago property manager is set to appear in federal court in Miami just hours from now.
Chris, we're talking about 56-year-old Carlos de Oliveira, who is expected in court this morning here in downtown Miami to enter a plea. This after being named as a third co-defendant alongside Donald Trump in the alleged mishandling of classified government documents after the former president left office. Prosecutors charged de Oliveira attempted to delete surveillance video at Mar-a-Lago after the Justice Department sought to obtain it. Meanwhile, Mr. Trump had this to say at his rally in Pennsylvania.
It's a great badge of honor because I'm being indicted for you.
No tapes were deleted. He turned them over.
That's an attorney representing the former president who denies accusations that Mr. Trump and his employees tried to delete surveillance footage from Mar-a-Lago.
When the person sitting at that defense table hands the government exactly what they need, wrapped in a bow, using their own voice, their own words, their own tone, recorded, authenticated, and played back for 12 people who did not ask to be there, but now cannot unhear what they just heard. You can challenge a witness, you can undermine their credibility, shake their story, make them look confused or biased or unreliable. You can fight documents, argue they were fabricated or taken out of context or never meant what the government claims they mean.
Out front tonight, the breaking news, a CNN exclusive tonight out front. K-File has unearthed photos of Jeffrey Epstein that we've never seen, and they shed new light on his relationship with President Trump. The revelations come as Trump is under fire from his own base for his Justice Department's handling of the so-called Epstein files. Trump has tried, of course, to distance himself from Epstein every which way. But one of the photos that K-File found confirms that Epstein actually attended Donald Trump's wedding to Marla Maples. And this is the proof. Again, this has never been published before, so this is a new image. You haven't seen it out there on X or anything like that. This is the proof that Epstein attended Trump's wedding at the Plaza Hotel in New York. And in the photo, what you see is Epstein entering the Plaza Hotel. The wedding date of this is December 20th, 1993, in the center of their friendship, which of course continued. And for comparison, we'll show you on the right a photo of Trump and Marla Maples at the same location under the entryway arch.
You can do all of that. But a man's own voice on a recording saying the exact thing prosecutors needed him to say, with forensic experts backing up every syllable and a federal judge ruling it admissible? That is different. That is the kind of evidence that does not get walked back. That is the kind of evidence that sits in a courtroom and stares at a jury until they reach a verdict. And that is exactly what just landed inside the federal court system connected to Donald Trump. Not a leak. Not an anonymous source whispering to a reporter who then writes a story everyone argues about for a week. Not a rumor floating around political circles. This is a 14-minute audio recording, officially filed by special counsel Jack Smith in a detailed submission to Judge Tanya Chutkan, and it is now part of the permanent court record. Sealed, authenticated, accepted, done. And what is on that recording? Let us be direct about this because the details matter and the details are genuinely stunning. The recording captures a phone call from December of 2023, Donald Trump speaking from Mar-a-Lago, on the line with a witness who was cooperating with federal investigators. And here is the part that makes this whole thing land differently. The witness on the other end of that call was smart enough to hit record, smart enough to capture 14 full minutes of conversation, smart enough to preserve exactly what was said while Trump was allegedly under the impression this was a private conversation that would never see the light of day. Now that recording sits in federal court. According to descriptions contained in the filings, Trump spends those 14 minutes doing something extraordinarily specific. He allegedly walks this witness through exactly what they should tell federal investigators, exactly what to deny, exactly how to frame events that prosecutors have been asking about. He allegedly coaches them on claiming memory failure about key conversations. He allegedly tells them to deny that a specific discussion about Mike Pence ever took place, even though prosecutors have evidence that it absolutely did. He allegedly hands them a script and says, essentially, this is what happened and this is what you need to say happened. And then he allegedly adds something that made legal experts everywhere stop cold. He allegedly tells the witness not to share this conversation with their own lawyer, not keep it from the media, not be careful who you tell. He allegedly tells them to hide it from the one person whose entire job is to protect their legal rights, the person who would immediately recognize what was happening and tell them to stop, to step back, to protect themselves. The person who exists specifically to prevent witnesses from being manipulated by targets of federal investigations. Trump allegedly told them to cut that person out entirely. Let that sit for a moment. A 14-minute call from Mar-a-Lago. A witness smart enough to record it. A sitting president allegedly telling that witness what lies to tell, and then instructing them to conceal the call from their own attorney. And now that recording is in federal court, authenticated, accepted, permanent. This is not complicated. This is not the kind of legal story that requires a law degree to follow. This is the simplest possible accountability scenario. A man under active federal investigation allegedly called a witness and told them exactly what false story to deliver to investigators and then told them to hide the call from their lawyer. That is the whole thing. That is the entire case in one sentence. And it is on tape. Think about what that means for a defense team. Think about what that means for jury selection. Think about what that means when 12 ordinary Americans sit in a room and hear 14 minutes of the defendant's own voice allegedly doing exactly what the statute says you cannot do. There is no spin for that. There is no messaging operation that changes what a jury hears with their own ears. The specific language matters here because it is not vague. Trump allegedly tells the witness to say they do not remember events that prosecutors are asking about. That is coaching language. That is the kind of instruction that signals one thing clearly. The real answer would be damaging. People who have nothing to hide do not call witnesses and tell them to claim memory failure. They say, tell the truth, I have nothing to hide, here is what actually happened. They do not script denials. The instruction about the Pence conversation ties this tape directly to the heart of the obstruction case prosecutors have been building. That conversation is not a minor detail. It is central to the timeline of events surrounding the certification of the 2020 election and the classified documents matter. Trump allegedly telling a witness to deny that conversation ever happened tells prosecutors something they already suspected. It tells them he knows that conversation damages his legal position. And it tells them he was willing to allegedly try to make a witness lie about it while the investigation was actively running. But the don't tell your lawyer instruction is the one that lands hardest. Attorney-client privilege exists for a reason. It exists so that witnesses and defendants can speak freely with their lawyers without fear that those conversations will be used against them. Your lawyer is on your side. Your lawyer is the person who tells you when something is dangerous, when something could expose you to criminal liability, when someone is trying to manipulate you into harming yourself legally. When Trump allegedly tells a witness to keep this call from their own attorney, he is not just trying to hide it from prosecutors. He is trying to isolate that witness from the one person who would protect them. He is trying to make sure no one tells them what they should already know, which is that taking instructions from the target of an investigation about what to tell investigators is a terrible idea. Legal experts keep using one phrase when they talk about this instruction: consciousness of guilt, because an innocent person does not care whether a witness tells their lawyer about a phone call. An innocent person has nothing to hide from anyone, including the witness's own attorney. The only reason to say don't tell your lawyer is if the call contains something the lawyer would tell the witness not to do. And that is exactly what witness tampering is. Now consider the Jack Smith filing itself. A 47-page submission to Judge Chutkan is not routine paperwork. It is a comprehensive evidentiary presentation designed to establish the foundation for charges that will eventually go before a jury. Smith including this recording is a strategic decision that communicates confidence in three things simultaneously: the tape's authenticity, its legal relevance, its ability to survive every evidentiary challenge Trump's defense team can throw at it. And Judge Chutkan accepting it into the official court record means it has cleared a threshold that the most aggressive defense team in American political history could not defeat. Audio forensics experts authenticated the voice as Trump's. The judge accepted the evidence. The tape is now permanently part of the federal court record. Trump's defense operation has one primary strategy for every damaging piece of evidence: claim it is fake, claim it is out of context, claim it is politically motivated. That strategy has worked in the court of public opinion for years, but forensic authentication and judicial acceptance close the door on those arguments before they can be fully deployed. The tape is real. A federal judge said so. Forensic experts said so. And it is in the court record where it stays regardless of what the political messaging operation tries to do next. This is also not the first time Trump has ended up on tape in ways that undercut his public defenses. The recording of him discussing sensitive military documents, telling people in the room that the material was secret and that he had not declassified it, was the audio evidence that most directly undermined his declassification defense. Now prosecutors have a second recording made more than a year later in which he is allegedly heard coaching a witness to deny conversations central to that same investigation. The pattern is the story, and the pattern keeps producing authenticated tapes. And every time a new recording surfaces and gets authenticated, it makes the fake and out-of-context defense weaker for every recording that comes after it. At some point, a jury stops believing that every tape is fake. At some point, the pattern becomes the evidence. Prosecutors know that, which is exactly why Smith's filing did not just introduce the tape. It introduced the tape in the context of a documented pattern of audio evidence that keeps pointing in the same direction. The sentencing exposure here is significant. Federal witness tampering and related obstruction counts stacked together represent exposure that communicates the severity of what prosecutors are alleging. A 14-minute recording allegedly capturing Trump instructing a witness to lie and to hide the call from their attorney is not a minor procedural violation. It is the specific conduct that statute was written to criminalize. And if prosecutors charge it fully and stack the related counts, the exposure is serious enough that this becomes one of the most significant federal criminal proceedings any former president has ever faced. 20 years for a 14-minute phone call that he allegedly made himself from Mar-a-Lago while under active federal investigation. This is not a gray area. This is a documented alleged criminal act captured in audio, accepted into federal court, and building toward trial. So here is where we land. When you line up everything, the 14-minute tape, the scripted false testimony language, the deny the Pence conversation instruction, the don't tell your lawyer direction, the forensic authentication, the Jack Smith filing, and Judge Chutkan accepting it all into evidence, you get the most complete single piece of the accountability picture this entire legal story has produced. The specific language on this tape is not ambiguous. I am telling you what happened, and that is what you need to say happened. That sentence, allegedly in Trump's voice on a 14-minute recording, is the formulation that converts a phone call into an alleged federal crime. It is not advice. It is not reassurance. It is a script for testimony Trump allegedly wanted a witness to deliver to federal investigators about events central to an active criminal investigation targeting Trump himself. The "don't tell your lawyer" instruction is the single most damaging line on the entire recording. Trump's legal team will challenge every other element of this case. They will attack the cooperating witness's credibility. They will argue context and tone. They will file every procedural motion available, but they cannot produce an innocent explanation for why a person with nothing to hide would tell a witness to conceal a phone call from their own attorney. That instruction is on the tape. It has been authenticated. The judge accepted it. No political messaging changes what it says. Jack Smith's filing and Judge Chutkan's acceptance of the tape are the two institutional developments that tell you exactly where this case is headed. Smith does not file 47 pages with an authenticated 14-minute recording at the center of it unless he is building toward trial. Chutkan does not accept that recording into evidence unless it has cleared her court's evidentiary threshold. The political noise around this case, the persecution claims, the dismissals of Smith as partisan, the social media campaigns, none of it changes the institutional reality. A federal judge has allowed a recording of Trump allegedly coaching a witness to lie to become part of the official court record. A secret 14-minute recording made in late 2023, a cooperating witness with a phone. Trump speaking from Mar-a-Lago during an active federal investigation. His own voice allegedly telling a witness to claim they do not remember, to deny a conversation happened, to repeat back a scripted version of events, and to hide the entire call from their own attorney, authenticated by forensic experts, filed by Jack Smith, accepted into evidence by Judge Chutkan. That is not a complicated story. That is not a story requiring legal expertise to evaluate. That is a story every single American can understand immediately. And the question it raises is the one that defines the entire accountability stakes of this moment. If a recording like this surfaces, clears every evidentiary hurdle, gets authenticated by experts and accepted by a federal judge, and still produces no meaningful legal consequence, then what does that actually say about the system that was supposed to hold power accountable? That is the question sitting underneath all of this. Not just whether Trump broke the law, but whether the law applies to him the same way it applies to everyone else. That is what this recording forces into the open. That is what the filing forces into the court record. And that is what the next phase of this case is going to be forced to answer in front of a jury. Stay tuned, because when that jury eventually sits down and hears 14 minutes of audio allegedly featuring the voice of the President of the United States, telling a witness what lies to tell and to hide the conversation from their own lawyer, the answer to that accountability question is going to be impossible to ignore.